Hello, my name is Brian Mayer. I'm an attorney practicing law in Southern California, and today I'm going to be answering the important questions of at what age can a child decide with which parents they want to reside, and if a child is not old enough to make that decision yet, what can be done to allow the child's wishes to be heard and considered in a courtroom setting. Now, it's important for this to not just hear the answer, because the answer is misleading. If you hear it, you may be thinking, oh, it's black and white, it's one way or another. But the fact is that there actually is some gray to it. And you really have to understand not only what the law is, but how it works and how it's treated in a courtroom to really know what to expect and to make sure that your kids are protected and your wishes are protected as well as a child in a courtroom setting. So the law is that there is no age at which a minor child can decide with which parents they want to reside. This is part of what makes them a minor child, is that they do not have the legal capacity to make their own decisions regarding their health and welfare, with very rare exceptions. They do not have the capacity to do that. Those decisions are left to the parents. And if the parents can't agree, it's left to the courts. But the child does not get to decide where they want to reside or with which parent they want to reside. It's simply not up to the minor child. Now, that's misleading because that makes it sound like there's just nothing that the child can do, that a parent wanting the child's wishes to be respected has no leverage or no power. And that's just not the case, because what the court does is the court recognizes that as children get older and they become more mature and more independent, that they are increasingly capable to weigh in on their desires as it relates to their custodial situation. And the fact is that even though the law treats adulthood as sort of this bright line where you're 17 years old and 364 days old in your child, and then the next day, 18 years old, you're an adult, and your child, bam, you're an adult. Human development is more of a spectrum, and it's a progressive. It's a process. We progress toward adulthood, and the court recognizes that with adolescence and sees that, okay, for example, a 5-year-old is not going to really have an opinion with where they want to stay or a reliable opinion. They may want to stay with dad because dad has dinosaur bed sheets, or they may want to stay with mom because mom doesn't make them eat fish sticks. A 5-year-old's not really going to be able to make good decisions for themselves. But as a child gets older, they're going to be more and more capable. So when a child starts to approach their teens, the court becomes more and more willing to defer to the child's wishes. And so at age 13 or 14, the court will usually give consideration to the child's wishes. In California, where I practice, actually at age 14, the child, for the most part, has the right at least to express their wishes to the court. But once you start getting closer to 15, 16, 17, the court will pretty much give the child what they want. Because once you start getting up there, once you reach age 16, 17, the child can drive and have a driver's license. They're old enough to seek emancipation if they really want to. And frankly, if they don't like it, a lot of times they're just bigger than the parents, and you can't force them to go visit the parent that they don't want to visit, not realistically at least. So as the child gets older, they have more and more power to decide, even though they don't have a clear right to make the final decision for themselves. And I can say that I've only seen maybe 1 or 2 cases where a 16-year-old has a strong opinion about where they want to stay, and the court did not grant that. And I don't believe I've ever seen a situation where a 17-year-old had a strong opinion with what they wanted in terms of where they would stay, and the court didn't defer to that. But especially if you're not yet in the teens, the court's really not going to give it much weight at all. because even if there's some difficulty in the relationship between one parent and the other, the court sees it at that age as being fixable. The barrier that people run into, though, then at that point, is they say, okay, my child wants to reside with me. They've expressed that they want to reside with me. I understand that they don't have the right to decide, so how do I get their wishes considered by the court? Well, there really are two ways. First of all, if the child, permission can be sought from the court to allow the child to be able to speak directly to the court. That's kind of a yucky sort of situation. I don't think any parent wants their child to actually be in a courtroom telling a judge what they want their custody situation to be. That's really unpleasant. It is an option if the court allows for it, but most parents want to avoid that for their child, but it is an option. A second option that oftentimes works better is to ask the court to appoint an attorney to represent the child, because that attorney can then speak on behalf of the child, express the child's wishes to the court, and it helps avoid the child from actually going into court and make their wishes known. The third option then is to have a custody evaluator or someone who's assigned by the court to interview the child and assess the custodial situation and come back and make a recommendation to the court. That's another way that the child's wishes can then be reported to the court without actually involving the child with the actual court process. So that's the answer. If you found this information to be useful, please consider subscribing to my channel. Please like the video. I have a lot of other videos available, and these other videos that I have are pretty much on the same topic, so if this was useful, those others may as well. Thank you so much.